Hello and welcome to today's live webinar with Matthews Folbig Lawyers. Great to have your company. I'm Daniel Kim, your host, and today we are talking about social media in the modern workplace, what all employers need to know. Social media is playing a greater role than ever in our lives, and over the last few years, the increased use of social media has blurred the boundaries between work life and home life, meaning that employers are now required to monitor and occasionally discipline employees for their out-of-hours activities. But just how much scope does an employer have from a legal perspective? And just because you can, should you? Well, joining me live in the studio today to help us navigate the many new hurdles arising from employee use and misuse of social media is Senior Associate at Matthews Folbig Lawyers, Peter Doughman. Peter, welcome.
Good morning, Daniel. Good to be with you.
Good morning. Great to have you on the program.
Thank you.
Now, this is a real grey area because it's not inherently an employment-related issue.
No, it obviously deals a lot with employment, but it crosses boundaries such as social policies, how far employers should monitor and control their employees, and it's also a technological issue because this is an evolving form of technology, and we're still coming to grips with it from a social perspective.
Yeah, and it makes it trickier because managing and disciplining employees itself is a difficult thing at the best of times already.
Absolutely, absolutely, and this adds an extra level of complexity to that otherwise difficult process.
Yes, clearly lots to cover on today's program, and as you can see, we are social distancing and observing the 1.5 metres here in the studio. And of course, you can also join the conversation today by clicking the dark blue hand icon at the top of your screen to ask a question. It will be coming through on this trusty old iPad. We've got a few questions in already, so we'll get through those at the end of the program. And of course, if we don't get to them, we'll get back to you offline, but we will aim to address as many of them. Also, if you happen to leave early today for whatever reason, please click the yellow button at the top to provide some feedback before you go. It would mean a lot to us if you did. So, like all good legal conversations, Peter, let's begin with some definitions. What do we mean when we say social media?
Good question. I think it's a good place to start because, as I mentioned before, it is an evolving form of technology. It's an evolving phenomenon. And it's hard to really reconcile how the scope of what social media really encompasses. So I think it's a good place to start with the definition, and then we can drill down beyond that definition. And as you'll see on the screen, I've got an appropriate definition for social media, which is essentially any form of electronic communication, such as websites for social networking and microblogging, through which users create online communities to share information, ideas, personal messages, and other content such as videos. Now, I do acknowledge that is a bit of a dense definition, and so let's unpack that further. The way I see it is that there are three broad categories of social media. The first one, which is the one that everyone's familiar with, is what I consider social networking, and that's your Facebooks, your Twitters, your Instagrams, your LinkedIns, and your Reddits. The second one is social communication, which is the one-on-one communication processes and platforms. That's your Facebook Messenger, your WhatsApp, Slack for Business, Zoom and Hangouts. And finally, the third category, which is the bit more of more towards the creative aspect of social media. That's your blogs on websites such as Blogger, podcasts, Tumblr and Medium, and also YouTube videos. So those three categories are the general broad brush. Those are the general broad brush definitions or what social media can encapsulate. But there are obviously quite a degree of overlap between them. So you might see that some aspects of social media might bridge both the social networking and the social publishing divide. For example, where an individual uses Facebook not only to create general posts, but also to express opinions in a large style blog.
Yes.
Yes, exactly.
Yeah, I was taken by the word microblogging. That's a very interesting concept. In fact, this has been interesting because I would have only thought of the social networking component to social media, but it's a lot broader than that, isn't it?
Exactly, and we're seeing new forms of the definition evolving all the time. For example, online gaming could be social media too.
Yes.
The communication through the microphones could be seen as social media as well. So it is evolving. It's complex to follow, and employers unfortunately have to be on top of it all the time.
So speaking of things that employers have to be on top of, what sort of workplace issues generally arise from social media related incidents?
Sure. So I've got a list here, which is what I consider the most common workplace issues, and this is not meant to be comprehensive by any means, and it's largely my experience. Without a doubt, the most common issue that arises as a consequence of social media activity is online bullying, harassment, including sexual harassment. Everyone's heard that story about an individual, an employee, sending a colleague sexually inappropriate messages or content. Social media is a minefield for that sort of behaviour. As well as that, we also see, even there's not so much bullying and harassment or sexual harassment, but there's disputes between employees using social media, which then is brought back into the workplace. So it damages workplace morale and productivity. That can essentially bring the workplace to a standstill. We'll also see that the misuse of social media by individual employees can result in a loss of trust and confidence between the employer and the employees themselves. And you'll see that occur when, for example, an employee makes a comment on Facebook or Twitter or happens to be that's critical or insulting about their employer. And so that can, if discovered, obviously cause a significant disruption in that employer-employee relationship. And the last major issue I see is the issue of reputational damage. And that, I think, can be drilled down into two different categories of reputational damage. The first one is where the employer is specifically identified, as I mentioned before, where an employee makes a comment that's disparaging or insulting about the employer. Mm-hmm. But there's another example, which is where the employee engages in conduct that causes embarrassment to the employer, and where the public associates the employee's social media conduct with the employer's values. This is becoming more and more common with what is often referred to as cancel culture, where you'll see an individual making a comment online or engaging in appropriate behaviour online, and members of the public will discover that conduct and identify who that person works for, and then challenge the employer to either discipline the employee concerned, i.e. get rid of them, or if they fail to do that, it would suggest to the public at large that the employer condones that sort of behaviour. And that can put employers in a very difficult position, because they are faced with that very difficult choice. Do they condone or ignore the conduct of their employee, even if it has nothing connected to the employment relationship, and therefore suffer the potential reputational damage? Or do they take that action and then face the risk of a potential dismissal claim? So it is a very hard line for an employer to walk.
It's almost the grown-up and or digital version of school kids behaving badly on the way home from school.
Exactly.
In their uniform.
Exactly right. And the fact that it's done outside the school gates doesn't mean the school has no involvement or has no say about that sort of conduct.
Especially when they're proudly displaying the school badge or crest.
Well, that's exactly right. And if there's reference to the employer, then that can have some real serious consequences for the employer.
Yeah, so these are pretty serious issues indeed, and it actually sounds like some potential legal risks to the employer too if it goes on unchecked.
Absolutely. So those are the issues that we see, but they can result in different forms of legal liability or legal risk and legal claims.
And so what sort of employment claims are you seeing?
Sure. So the main one I see, and certainly the one that I'm asked to advise on and assist with most commonly, is where employees make complaints or grievances about conduct between themselves and other employees. So there's a workplace dispute or interpersonal dispute between employees, where part of that dispute is carried out online. And so employers often call up and ask, to what extent do I have the power to police or discipline employees for this sort of conduct when it's brought back into the workplace? So the complaints or grievances is a main one, and certainly a serious one. There's also the issue where employees don't make a complaint to the employer, but in fact just go straight for an application for a stop bullying order with the Fair Work Commission. For those who may not be familiar, because it's not as often used as other remedies such as unfair dismissal, the Fair Work Commission has the power to make orders against employers and other persons to stop bullying from occurring in a workplace. So an employee who believes they are being bullied in the workplace, whether or not it's physically in the workplace itself or online with other employees involved, can essentially just make a complaint to the Fair Work Commission for an order to have the bullying stopped. So that's another one that occurs quite regularly. Separate to those, but I think often leading out of them, is the other issue that we see where employers request our advice and assistance with workplace investigations, where there has been obviously a dispute, an issue in the workplace that's arisen as a consequence of social media activities, and you as the employer are obliged because of a policy or because of your general work health and safety obligations to investigate that. And so you need to conduct a workplace investigation to root out the root cause of the issue and take the appropriate action to make sure it doesn't keep on happening. Now, workplace investigations can be quite a costly exercise to undertake, especially for small and medium businesses who may not have a dedicated employer, an HR manager who can conduct that investigation. It's also important when you conduct a workplace investigation to make sure it's conducted as impartially as possible and free from either actual bias or perceived bias, apprehended bias. And so you need to make sure that the person who's doing the investigation is not involved in the issue itself. And finally, for those small and medium-sized businesses, you may not actually have anyone who has the skills, the experience, or even the resources to do that. And in those situations, you may have to engage an external workplace investigator to do this for you. And we find that they can be quite expensive for employers. We see typically between $5,000 and $15,000 for a workplace investigation, which is a lot of money on top of the drop in productivity. And it can cause further disruption of the workplace. So it's a costly and difficult option. And even once the workplace investigation is completed, that usually only results in findings being made. You as the employer have to take action based on those findings. And so you've incurred all this time and expend all these resources in conduct the investigation. You have the report. But now you have to take the action. And then the risks for dismissal claims arise again. The costs keep on escalating. So it's important to nip these things in the bud as soon as possible. And if it's all possible, try and avoid it from occurring in the first place. And a little bit later, we'll get into the best ways to do that.
It's a triple whammy too, if you think about the culture and the workplace relationship side of things too. So you've got the productivity that you lose,
Indeed.
the actual costs that you have to incur,
Yes.
and then the breakdown of relationships with your employees and the staff.
That's right. And the risks that you'll have to pursue this claim or defend a claim, you might be unsuccessful. And if you're unsuccessful in defending a claim, then it gives the employees who are still there carte blanche to keep on engaging in that sort of behaviour. So it can be a vicious cycle for employers. But the other legal consequences that often arise, and these are probably the most common formal legal options or formal legal issues that arise, are the twin remedies for employees of unfair dismissal claims and general protections claims. And they're both claims made under the Fair Work Act. They have different purposes or approaches. And so I'd like to just take a few seconds to explain the difference between them for those who may not appreciate the difference. An unfair dismissal claim, which is what most employers tend to bring after they're dismissed, is where the employee alleges that the dismissal was harsh, unjust, or unreasonable. And in a nutshell, that involves the employee alleging that there was no valid reason for the dismissal. It was either an invention or it had nothing to do with the employment relationship itself, and that's a key issue we'll get to shortly, or where there was a lack of procedural fairness in the process leading up to the dismissal, or where the dismissal was otherwise harsh, where the punishment didn't fit the crime. And so there's a whole lot of steps, there's a whole lot of things that employers need to get right. Any step wrong, you might fall in the creek and then you'll be faced with an unfair dismissal claim and a potential risk that defence of that claim will be unsuccessful. So that's unfair dismissal. The other side to this coin is what's called the general protections claim or an adverse action claim. And that deals less with the process or the reason and deals more with whether the reason itself was prohibited or otherwise unlawful. Now, the Fair Work Act's general protections have a whole range of prohibited and unlawful grounds for which an employer cannot dismiss an employee or take adverse action against an employee. But the main ones for our purposes is prohibitions on dismissal or adverse action on the ground of religion or political opinion. So, for example, if you dismiss an employee because of a comment they made on Facebook or Twitter about their political values or about their religion, then that may be seen as unlawful and the employee would have a claim. And you actually have to prove that the reason for the dismissal was not for the unlawful reason alleged by the employee, that the true reason was not the unlawful reason alleged. And that can be quite a difficult and certainly costly process because these claims are run in the federal circuit court and the federal court. So these can run up to $80,000 or more to defend up to hearing.
I mean, it's certainly a very layered and nuanced area to be dealing with.
Absolutely.
And I think talking about the points on the grounds of religion or political opinion, I think the example that most people can think of in a public, in the most recent couple of years would be the Israel Folau case.
Exactly. And that's where I think this issue of the general protections on the grounds of religion and political opinion came into the public eye. And so for those who may not recall or somehow missed the whole brouhaha from a few years back, Israel Folau is a professional rugby player, football player, who's played for various codes. And his employment was terminated, his player's contract ripped up after he made a fairly inappropriate and insulting post on Twitter, which you can see on your screen now, which basically claims that drunks, homosexuals, adulterers, liars, fornicators, thieves, atheists, and idolaters have hell awaiting for them unless they repent. So I would expect that atheists probably wouldn't be too concerned about that. But for example, people who might be religious but otherwise homosexual might find this quite insulting. And so there was quite an outcry about this. And it's important to consider this issue in context. The background to this particular post was that a few years prior, during the Australian same-sex postal vote survey, various religious groups came out, obviously in opposition to the same-sex marriage proposal, and as part of that, Israel Folau, who belongs to a religious group, who's quite passionate in opposition to that position, made quite a number of public statements and including on social media, in opposition to the same-sex marriage proposal, and that caused a lot of unwanted attention for both Rugby Australia and for their sponsors. So that obviously was a concern to Rugby Australia, and so after that whole postal vote issue died down, at the time that Folau was to come and re-sign his contract, Rugby Australia made it a condition of the contract that he must at all times comply with the code of conduct and the various policies that Rugby Australia have in place, and in particular those policies and code provisions relating to the acceptable use of social media, that he must not bring rugby, the code or the game, into disrepute because of his social media activity. And Folau agreed with those conditions and he signed the contract, and then lo and behold he made his post. And following the post being made, there was an investigation, there was a review process, and Rugby Australia concluded that the conduct was a high-level breach of his contractual terms and his employment was terminated on that basis. And Folau then claimed through legal proceedings that the reason he was dismissed is because of his post was on the grounds of his religious beliefs and his religious activities. And that's how the whole issue became largely in the public eye. Just moving on to the next slide, if I may. And I'll be here. Anyway, the decision was never ultimately decided because the matter was settled, fortunately for the parties, but perhaps unfortunately for us, because we don't have that guidance as to which way the court would have come down on this very contentious issue. For a while, it was looking like it may not have mattered because of the proposed legislation, the religious freedom legislation, which the government intended to pass, which has seemingly fallen by the wayside due to COVID and changing electoral attitudes. But essentially, that is an unresolved question as to when can an employer police and discipline an employee for their religious conduct, their religious beliefs, and their religious activity. And so that's something that we may still see resolved in the future.
Yeah, it's a fine line, isn't it?
Absolutely.
It'd be interesting to see where precedents get set in the legal field.
Exactly. And so without being too much of a rubbernecker, I can't wait to see how these sort of issues get resolved over the next few years.
Well, there have been other cases which have formed what you call Touchstone cases.
Yes.
That have given some guidelines for other companies.
Yes, absolutely. And so when you look at, certainly when lawyers come to look at these very complex issues where to consider and analyse how much power an employee has, or how much control an employer has to discipline its employees for their conduct, we look at prior decisions of courts and tribunals. That's known as that's usually what's called the common law. And in Australia, there is one touchstone common law decision dealing with the issue of out-of-hours conduct. And that is the case of Rose and Telstra Corporation from back in 1998. It actually doesn't deal with social media at all, but it is considered to be the key case following which all the social media decisions have referred to and flowed, because it sets out a number of principles that need to be taken into account when you consider out-of-hours conduct. For example, social media conduct, social media activity outside the working hours, outside the actual physical premise of the workplace. So just to give a brief outline of the case of Rose and Telstra, essentially Mr. Rose, who was the applicant in the proceeding, was a Telstra technician who was based in their Tamworth office, and due to an influx of work at the Armidale office, was sent on for work purposes to assist the Armidale branch with their technical issues. And as a consequence, him travelling to the other branch or the other office, he made arrangements to stay with another colleague who also had to travel there, and they stayed in a hotel together. It seemed like, from all intents and purposes, the relationship between the two was fine for the first few days, but several days into the stay together, they all went out for dinner and some drinks, and that resulted in the other colleague becoming intoxicated, and in fact attacking, when they returned to the hotel room where they were both staying, the colleague attacking Mr. Rose with a piece of broken glass which he'd broken from a window. Mr. Rose had to go to hospital and receive several stitches. So it was clearly an issue that resulted in a real risk to health and safety for Mr. Rose. For whatever reason, when the matter was reported back to Telstra, they determined, following investigation, that Mr. Rose was responsible for exacerbating the issue, for encouraging the incident to arise, and dismissed him for misconduct. Now, following the dismissal, Mr. Rose brought what essentially was an unfair dismissal claim.
Wait a second, Mr. Rose got dismissed?
Mr. Rose got dismissed and brought a claim alleging that it was an unfair dismissal, because he said, and his argument was, that it didn't happen during work hours. It was out of hours. It didn't happen on the work premises. Neither of them were wearing their Telstra uniform. And at no time during the incident, which was, although it wasn't particularly public, it was in a hotel, which is sort of private premises, but in no way was Telstra at all referred to or involved in any way with the incident. So Mr. Rose understandably argued that this had nothing to do with Telstra whatsoever. It was just a private incident, and it wasn't a valid reason for dismissal. And the Australian Industrial Relations Commission sided with Mr. Rose. That they found that the dismissal was unfair because, and they agreed with the argument that it had nothing really to do with Telstra whatsoever. When determining the issue, the Commission, the Australian Industrial Relations Commission, formulated this particular principle, which is always seen and referred back to in subsequent cases, especially those cases dealing with social media. Essentially, the Commission said that employees' employment may be validly terminated for out-of-hours conduct, but only in the following limited circumstances. Firstly, where the conduct, viewed objectively, is likely to cause serious damage to the relationship between the employer and the employee, or two, where the conduct damages the employer's interests, or three, where the conduct is incompatible with the employee's duty as an employee of the employer. In essence, putting all those together, the conduct complained of must be of such gravity or importance to indicate a repudiation or a rejection, a fundamental breach of the employment contract between the two of them. And finally, there must be a clear connection between the two of them. It just can't arise in a public place outside and completely divorced from the employment relationship. In that case, the employer has no real control or no right to police or discipline an employee for that sort of behaviour.
Can I ask a few questions as a non-legal person just hearing this story?
Certainly.
I mean, first of all, it's a shocking story.
Yes,
that it happened.
It was, yes.
So Mr. Rose was the attackee and he got dismissed. Did anything happen to the attacker?
He was subsequently also dismissed. funnily enough, at the time where he was, at the time of the incident, the colleague was out on bail for previous assault.
Whoa.
And one of the conditions for his bail was that he not consume alcohol.
Ah.
And so he was ultimately dismissed by Telstra, not because of his conduct, because of the breach of bail conditions.
Well, that's a bit of a cop-out.
It's a crazy one. And one could argue somewhat conspiratorially, and it's noted in the case, that the other employee was a well-known friend of the supervisor.
Ah.
But that's not one that the court considers. That's not an issue the court considered. And the court didn't need to consider.
Would the commission ever consider that in terms of unfair, what was it, procedural unfairness?
Well, they could have considered the way that Mr. Rose was treated was disproportionately worse to the other employee. And that may have been a factor in the decision. But ultimately, the threshold issue for the commission was that it just wasn't sufficiently relevant or connected with the employment relationship.
Right.
That lack of connection meant there was no valid reason for the dismissal. Telstra could not rely on the issue to justify the dismissal of
Did
Mr. Rose.
Telstra say anything along the lines of he was there on business, like none of this would have happened had we not needed him to go from Tamworth to Armidale?
Well, that was certainly one of the arguments that Telstra tried to advance in defence. But the Commission pointed out that, as I mentioned earlier, it was out of hours, it was outside the premises, none of them were wearing their uniform, and no one around who saw the incident knew that they were Telstra employees. And even though the matter was the subject of some gossip in the Telstra offices in northern New South Wales following the incident, there was no evidence whatsoever that there was any reputational or other damage sustained by Telstra at all because of the incident. The sad irony, of course, is that Telstra was unsuccessful in defending the claim, and so the only reputational damage is arose because they dismissed him.
Right. I'll just think, just from a purely common sense perspective, that violent conduct is violent conduct and that shouldn't be condoned.
Well, exactly right. And I think that when it comes to these sort of issues, and that's one of the points that I'll raise when we get to practical approaches, is you need to be sensible about these things. You need to consider the conduct, consider how it affects the business, if at all, and approach it rationally, impartially, and most importantly, compassionately. Because if you make a too heavy-handed decision, that might come back to bite you if the employee brings a claim.
Sounds like all good common sense stuff, but probably easier said than done.
Absolutely.
Particularly looking at this case.
Yes. So moving on from that particular case, which, as I said, it had nothing to do with social media specifically, but has been referred to in all subsequent cases dealing with out-of-hours social media usage. And the way I see it, in my view, and there have been a number of cases dealing with this over the years, there are three main Touchstone common law cases dealing with this. They all arose in the context of unfair dismissal, and they all arose, and they're all decided and heard in 2011, funnily enough, shortly after the Fair Work Act was introduced the previous year, or the year and a half. So I'll just go through these now, and then once we've gone through each of the cases, I'll try to draw some through lines for principles and some takeaways to hopefully allow you as employers to see where the traps are, what the risks are, what to avoid, and what steps you should take to protect your position as best as possible. So the first one that I'd like to discuss today is the case of O'Connor and Outdoor Creations. As I said, that's from 2011. And the employee involved, Mr. O'Connor, was employed by Outdoor Creations, seemingly in a somewhat clerical or administrative role. He was in front of a computer substantially for most of his employment, and that was part of his role, is to work administratively. And he was dismissed after the employer discovered that over the period of his total employment, he had engaged in excessive social media usage. In this particular case, he used the Google Chat feature that was part of the Google Gmail service, and there was evidence that he had racked up some 300 hours worth of chat time on Google Chat during the period of his employment. And the employer argued that essentially for him being paid to do work, but him not doing work because of this use of the chat service, that he was effectively stealing from the employer. That was the argument they raised in dismissing him. Now, Mr O'Connor brought an unfair dismissal claim against Outdoor Creations, alleging that there was no valid reason for dismissal. And the Commission, or the Fair Work Australia, agreed with that proposition and found the dismissal was unfair on the basis there was no valid reason. And in reaching that conclusion, they took into account three main factors. The first one, which is the most obvious one, which shows that Outdoor Creations were quite careless in their approach to both the dismissal and defending the claim, is that at no time did they have any evidence whatsoever that the social media usage by Mr O'Connor was wholly or even substantially during his working hours. So they had somehow obtained evidence of the total number of hours he had been on Google Chat from the date of commencement to the date of discovery. But they didn't have any evidence as to what times that social media usage had occurred. Was it during working hours? Was it during breaks? Was it after hours? So they didn't have that evidence at the time of dismissal. And seemingly they didn't have that evidence before them at the time of the hearing of the case. So the Commission couldn't really find in favour of their argument that he was engaging in this appropriate out of hours, during hours conduct. In addition to that, it was found there was no evidence at all that the employee's performance was poor during his employment, or that it was negatively impacted because of the use of social media, whether it was during or outside of hours. And thirdly, and this will come up and again, so put a pin in it, the Commission noted that the employer had no policy prohibiting or otherwise restricting social media use during working hours. And for those particular reasons, they found that there wasn't enough evidence to substantiate that the employer was essentially stealing from the employer during his employment, and found there was no valid reason. So Mr O'Connor got away from that with a remedy and a finding in his favour. The next case which I'll look at, again also from 2011, is the case of O'Keefe and Good Guys. Now, Mr O'Keefe was a retail employee employed by the Good Guys, or a particular franchise of the Good Guys stores. And it was discovered that during his employment, he made a number of highly inappropriate, insulting and threatening Facebook posts regarding his employer. And one of which is the one that I've included here, which I will censor when I set it out, but you can interpret it. It's wonder how the F work can be so effing useless and mess up my pay again. C's are going down tomorrow. That obviously is quite an offensive comment to make about one's employer. And when the employer discovered that post, which was reported to them through a mutual friend, a Facebook friend, who obviously must have been an employee of the employer, but also a Facebook friend of the Mr O'Keefe himself, they conducted an investigation. They interviewed Mr O'Keefe about the comment. And during that interview, Mr O'Keefe admitted that the reference to the C was in reference to the employer's female operations manager, with whom he had an ongoing dispute over his pay and his working conditions. On that basis, the employer found that the employee had engaged in serious misconduct by making sexually explicit, inappropriate comments and threats towards the company, the business, as well as a particular manager involved, and dismissed him on that basis. And again, Mr O'Keefe brought an unfair dismissal claim. At this particular time, the employee was unsuccessful, and the Fair Work Australia found the dismissal was fair. And that finding came down for these reasons. Firstly, the post was accessible to several other employees of the employer. So it was known it had the capacity to cause disruption in the workplace. And more importantly, referred to Mr O'Keefe's ongoing pay dispute, which had potential reputational damage consequences for the employer, and morale issues could have arisen as well. Secondly, the post itself, as everyone could understand, includes sexually inappropriate threatening language, which was intended for a specific employee. I think that argument's a bit unfair because the post itself doesn't refer to who the C was. It was only in the course of an interview that was found. But nevertheless, that's the way the Fair Work Australia found, or partly found, that the dismissal was fair. And thirdly, and I think this is probably the most relevant factor, that the employer had an employee handbook that prohibited sexual harassment and bullying in all forms. So essentially there was a policy that outlawed the particular conduct involved. It didn't specifically relate to or encapsulate social media conduct, but it said that it it prohibited this sort of conduct in all forms. And so that was considered by the commission involved, the commission when it determined this case, that it was wide enough, that policy provision was wide enough to capture the conduct of the employee. And so Mr. O'Keefe, unfortunately, was left without a remedy in this particular case. The third case is the case of Stutzel and Lynn Fox, and again, 2011 case for whatever reason. And in this particular case, Mr. Stutzel, who was the employee, was dismissed for a series of posts and comments which he had made on his Facebook page, or which were on his Facebook page rather, which were racially and sexually derogatory towards two of his managers. Specifically, one of his managers was a Muslim, another manager of his was a female, and so a set of posts and comments on his Facebook page were derogatory towards one of his managers on the basis that that manager was a Muslim and against Muslims in general. And other comments were derogatory towards women and the female manager in general. After the employer discovered this and conducted investigation into it, they dismissed Mr. Stutzel on the basis of the inappropriate Facebook posts. And Mr. Stutzel brought an unfair dismissal claim. And in this case, the Fair Work Australia found the dismissal was unfair, that there was no valid reason for the dismissal. And their findings were based on these grounds, that firstly, they had to take into account the characteristics of Mr. Stutzel. He was an older employee. He was seemingly a bit of a technical novice, and he gave evidence, which was unchallenged, that his wife and his daughter set up his Facebook profile, and he believed, based on what they told him, that they had applied maximum security and privacy settings to the Facebook profile. The Commission also found that the comments were offensive and inappropriate, but not disproportionate to the workplace itself, as you'll see that it's Lynn Fox. And so they saw that the comments themselves were like akin to pub talk, and that they weren't much more serious or inappropriate to what you may have overheard being uttered in the course of a trucking business or in a trucking workplace. The Fair Work Australia also noted that there were quite a number of more serious comments made on his Facebook page by his friends, but he couldn't be held responsible for that. The employer said that he should have taken steps to delete those posts, but his argument or his evidence in response is he didn't know how, and that was accepted. And finally, and again, this is one of those times we need to put a pin in this point, despite the size and the resource of the employer, they didn't actually have a social media policy or any other appropriate policy dealing with this sort of conduct, either at the time or when the matter came to hearing. And so those were the reasons why the employer was unsuccessful, that they found that there was no valid reason Mr. Stutzel shouldn't have been dismissed on these grounds. So putting all these cases together and trying to come up with some key takeaways, I think it's important to provide this list so people can actually see and take note of these, because they are quite helpful as takeaways. Firstly, as I mentioned when we were putting various pins in points, the policy is the best protection. If you can have a social media policy, or failing that, an IT policy which refers to social media use, or even a general code of conduct which has a provision or provisions dealing with social media usage, that is the best basis for you to police or include prohibitions against conduct and police, monitor and discipline employees for breaches of the policy. The flip side of having the policy is you need to make sure it's applied fairly and consistently. It's no good having a policy that prohibits certain forms of conduct and then you as the employer promptly ignore that, because if you ever come to try and discipline an employee for a breach, that prior failure to apply the policy fairly will come back and bite you. And a policy that's not consistently applied to is almost like having no policy at all. The next point is to the best extent possible, don't distinguish between conduct in the real world and conduct online. If you have a a policy provision which prohibits bullying and harassment and discrimination, which you should, then that policy provision should say that it extends to any social media use or any interactions using social media or online interactions with other employees, including out-of-hours interactions. Then even if these are all satisfied, you have the policy in place, it's applied consistently, and it's appropriate to take action because of the breach of the policy, that doesn't give you carte blanche right to simply terminate the employee. An important takeaway, both for social media purposes and generally, is that if there's a valid reason, the next step is to make sure that you afford the employee appropriate procedural fairness. That means you need to have appropriate evidence of the alleged conduct. That's going back to the issue of the outdoor creations case. Next is to provide the employee with advance notice of the alleged conduct and the consequences of a finding that he engaged in the conduct. So you put the employee on notice of the issues in writing so they are aware of the concerns, and that potential disciplinary action may flow, including up to and including dismissal. And those are the key words, up to and including dismissal. You should then provide the employee with an opportunity to respond to and explain the alleged conduct. There may be context that's important. There may be mitigating circumstances that are appropriate to take into account. Next, you should not consider the investigation and the interview just a tick-the-box step. You need to genuinely consider the responses and the explanations given by the employee. Take some time to think about it, mull it over, go home and sleep on it if you're the decision maker. Don't be too hasty to find that the employee has to go. And finally, and that leads into this final point, objectively consider the seriousness and the consequence of the conduct before taking the disciplinary action. The key takeaway is make sure the punishment fits the crime. If you are too heavy-handed in deciding to dismiss an employee for inappropriate workplace conduct, whether it's online or otherwise, then that may still give rise to unfair dismissal risks because the dismissal is harsh. There may be a valid reason. There may be procedural fairness has been afforded to the employee, but if the decision to dismiss is harsh, then that might be all that a commissioner needs to find in favour of the employee. And there often are policy reasons why the commission, for whatever reason, will find in favour of an employee or do whatever they can to at least provide an employee with some form of remedy. So those, I think, are the main takeaways for dealing with breaches of the policy.
Yeah, I think the theme that you consistently asked people to pin during the cases was to, first of all, have a policy in place that you can refer to. And the other thing I'm getting from you is the importance of having a structured approach to both setting the expectations and outlining the procedures afterwards.
Yes, exactly. And I can't overstate the importance of having a policy. I'd like to just mention very quickly a particular case which isn't in the slides, but it's a case that was from 2 years back, I think, which was Comcare and Banerjee. And this was a case where Mrs. Banerjee was an employee of the Department of Immigration and Border Protections. And it was discovered during her employment that she had operated a Twitter account which was in which she had made comments which were critical of the department and also the minister involved, the minister for the department. And she was dismissed because of breaches of a policy, Australian Public Service policy that prohibited this sort of conduct and prohibiting any conduct that may have the tendency to cause the public to lose confidence in the public service. It's a very wide policy provision, a very wide policy prohibition. And Mrs. Banerjee, in this particular case, she both brought an unlawful termination or an adverse action claim against the department, but she also made a workers' compensation claim, alleging that as a consequence of the dismissal, she suffered an injury, a psychological injury, and sought benefits with Comcare, which is the Commonwealth Workers' Compensation Scheme Administrator. That decision was declined on the basis that she had essentially breached the policy. And it's important to keep in mind that Mrs. Banerjee's Twitter account was anonymous. It didn't refer to her, it didn't identify her. It obviously had some other name. But more importantly, it didn't identify her in any way as an employee of the department. So essentially she had an entirely separate online identity that she administered. there's no evidence she engaged in these sort of tweets or this sort of activity during working hours or in the office. But nevertheless, she was punished and disciplined and ultimately dismissed because of her online conduct. The only connection was that she was an employee of the employer whom she would occasionally complain about. And in this particular case, she brought an argument. One of her arguments was that the dismissal was contrary to the constitutional right, the implied right of the freedom of political communication. Now, in Australia, we don't have a right to freedom of speech like America does. But in Australia, we do have an accepted implied right of the freedom of political communication. She said that the decision to dismiss her for her political opinions, her political beliefs, was a breach of this implied constitutional right. And it went all the way up to the High Court. And the High Court found that, yes, there is an accepted implied right of the freedom of political communication, but that has to be tempered by the fact that she was an employee of the employer, and it undermined the confidence the employer had in her when it discovered it. And secondly, there was a clear policy. The policy essentially saved the department and allowed it to properly defend the claim. So the takeaway is make sure you have a policy in place. That is if there's one takeaway for today, is get a policy prepared, modify your existing policies to ensure that conduct outside of hours, especially online activity, especially online conduct, is subject to monitoring, policing, and potential disciplinary action.
Got you. So the key takeaway is make sure you've got a proper working policy in place.
Absolutely.
And you used terms before like up to and including dismissal as key terms to include on it.
Yes.
Can you take us through some of the other terms that are important for employers to know about when making a policy?
Absolutely. So I've on this and the next few slides, I've set out what I think are the principal policy provisions which should be in any particular policy. And obviously, policies need to be drafted while having regards to the particular circumstances of the employer, the industry of the employer, and the potential employees. So a policy for professionals such as lawyers or accountants may be quite different to a policy for retail employees, or maybe very, very different for a policy relating to the employees of media media figures or celebrities, for example, people employed by the commercial channels or the commercial networks. So you should always consider the circumstance which the policy is being prepared and the circumstance which the policy will need to be applied. But I think these are the key takeaways. These are general principles that should appear in virtually all social media or other applicable policies. Firstly, I think I'm on the wrong slide. Let me just find the correct one. Okay, I think we're out of order here, but we'll struggle through. Firstly, the policy should make clear that whether the employer has a zero tolerance approach to any use of social media during working hours, and if so, why. So if you are reliant on productivity, if you are working to deadlines or you have billable hours, then you may want to apply a zero tolerance approach to any use of social media. Or if that's not critical, you may just want to prohibit excessive use of social media. And if you're going to do that, you should really define what excessive use means in the circumstances. The next takeaway is that the policy should specify that employees are prohibited from using any form of social media to engage in any bullying, harassment or discrimination against or towards other employees. That should include and encapsulate either during or outside working hours. That means you have a specific policy provision saying that you must not engage in this sort of conduct because it can give rise to those issues and those potential liabilities we were referring to earlier. The next point is that the policy should specify that employees may not use social media, including any form of social networking, to send pornographic, violent, offensive or inappropriate material, because obviously that may give rise to liability for you as the employer as well. And finally, the policy should specify that the employees must not use the employer's IT equipment in order to engage in any appropriate social media activity. So with those 4 points, you're essentially capturing or expanding the scope of the regulated conduct as widely as possible. It's during working hours, conduct towards other employees, conduct using the employer's property and IT resources. So those will allow you to control, monitor and police any form of social media conduct, including that outside. The next point is to specify that the employees must not use social media in any form to disparage the employer or its management or negatively refer to the employer in any way. And so that's what we were talking about in the Banerjee case, is that the employee disparaged the employer or made comments which were negatively focused towards the employer. Next, you should specify in the policy that employees must not make any comments in which they purport to represent or speak on behalf of the employer. And leading into that particular point, for those employees that might have a public presence, and this is usually in the case of either reporters or journalists or media personalities with whom you can identify the employer easily, for example, someone who's a celebrity on a particular network, you should make sure that if they have a social media presence, that they at all times include an appropriate disclaimer that their personal opinions expressed on social media do not represent the opinions of the employer. And finally, you need to make clear and specify in writing that employees must not engage in any social media or online activity that brings or is liable to cause the employer embarrassment or reputational damage. And this is vitally important if the employer has a well-known public presence, for example, Rugby Australia, because even if the conduct was entirely outside the realm of the workplace, like the Falau example, it did cause direct and clear damage and unwanted attention on Rugby Australia because of the pressure applied on both it and its sponsors. So those are, it's important to try and nip in the bud conduct that may negatively impact the business's reputation. And the third point is, as we were discussing earlier, is that you need to make clear that any breach of the policy is liable to result in disciplinary action against the employee up to and including dismissal. You need to make sure that it's clearly expressed, so employees are on notice, that dismissal may occur for a breach. Because if it doesn't say that, then they could argue, the employees may genuinely argue that they didn't know they were about to get dismissed. So if it's in writing, then they're on notice and they can't argue that. That's not an argument they can raise. You should also include a provision in the policy that specifies that it should be read in conjunction with the other policies and codes of conduct. So any conduct prohibited by any other policy will similarly be prohibited if engaged in online. And that's essentially a catch-all for any bullying, harassment or discrimination conduct engaged on social media, even if it's well and truly outside the workplace. Obviously, that would need to be between employees. So it couldn't simply be an employee towards a third party, like another member of the public. And finally, and this is just a precautionary principle, is that in several states and territories, particularly New South Wales, there are overriding legislative obligations on employers to notify employees that they may be subject to workplace surveillance from time to time. And there's different forms of workplace surveillance. For our purpose, there's electronic surveillance or computer surveillance. So you need to put the employee on notice, and the policy is sufficient, that the employer may monitor the employee's computer usage, their email usage, their web and browsing history, and any content that might be saved to a work device from time to time. So, for example, if employees are issued with a work phone or a work laptop, then you, as the owner of those devices, have the right to inspect those devices for any inappropriate material saved to it or any inappropriate communications used during those devices. So those are the key policy inclusions I think that we should that need to be had regard to. And if those are in place, then you stand you're in best standing to protect yourself against any claim that may arise if the worst case scenario does occur and employees engage in inappropriate conduct online.
Yes, that's very detailed. Thank you very much for taking us through all of those. We've actually only got 5 more minutes left now, and we still have 2 big topics to tackle before we hit Q&A. So yes. I think we can safely say that we're not going to have time to address your questions online today. We've got a fair few questions that are coming through. So please know we're not ignoring you. Peter will get back to you with all of the with responses to all of these offline. Now, in the 4 minutes, maybe 3 minutes that we have remaining,
yes,
maybe let's talk about the the whole case of taking disciplinary action, because it's one thing to form a social media policy and tell people what the guidelines are and have that communicated. It's another thing altogether when it comes to having a structured approach to applying the penalties.
Yes, exactly. And as I've mentioned, employers should be not too eager to take a heavy-handed approach. Don't jump in too quickly. Don't be too hasty, and don't consider the matter impartially and honestly and openly before you make the decision. And I think the case that best illustrates this is the case of Tracy and BP Refinery from earlier this year. Now, for those people who aren't familiar with this particular image of this very unhappy, mean fellow on the screen, this is a still of a scene from the movie called Downfall, which came out quite a few years back. And although the film itself was quite a serious and somber film about the last few days of the Third Reich and of Hitler's life, it's over the last 10 years since the film came out, has been co-opted and essentially converted into a meme or a parody or a satire where individuals get the footage and superimpose subtitles dealing with all manners of different subjects unrelated to the subject matter of the film. And in this particular case, Mr. Tracy was employed by BP Refinery, or BP at its refinery in Western Australia. And in the course of ongoing and very protracted pay negotiations between BP and employee bargaining representatives following the termination of their old enterprise agreement, Mr. Tracy, in a fit of creativity, decided to create and then post to a private employee group a version of the Hitler downfall meme where he essentially referred to the issues and the position adopted by BP and basically slated that to what the Hitler character was saying. That was brought to the attention of BP, and they thought that the conduct warranted disciplinary action. They asserted that Mr. Tracy, in making the video, essentially likened BP management to Nazis and dismissed him on that basis. And so Mr. Tracy brought an unfair dismissal claim, alleging there was no valid reason for dismissal, and he was unsuccessful at first instance. So at first instance, a single member of the Fair Work Commission found that there was a valid reason and that this was gave rise to a irreparable breach of the employment relationship, the relationship of trust and confidence. But on appeal, the full bench of the Fair Work Commission found that the dismissal was unfair. And the Fair Work Commission, and presumably the people who were on the bench at the time, had more of a knowledge or a context of the parody and saw that it's clearly a continuation of the parody. It didn't intend to actually liken BP to Nazis. They looked at this reasonably and rationally. They also saw that the video was originally shared in a private Facebook chat and didn't have any actual adverse public reputational effects on BP. And finally, although it was shown in the evidence that the employee did use a work computer to show the video to another employee, that wasn't sufficiently serious to justify dismissal. So for making this video, Mr. Tracy was ultimately found, it was found that Mr. Tracy was unfairly dismissed and he got a remedy for that finding. So I think that's a principle to keep in mind, is that don't overreact. Take into account the factors, the circumstances, and the context in which conduct arises, especially online, because it is an evolving field. And conduct online has to be looked through a particular lens, especially when you're dealing with things like satirical videos, footage, creations, parodies, stuff like things like that. And that, I think, is a key takeaway from that case.
Yes, absolutely. Now, we are going to have to leave it here.
Yes.
You did have one more point to make, and that was to highlight the actual positives of social media, because there's a whole lot of potential there. We can't get into all of it now, just in the interest of time.
Yes.
But this is a topic that Peter is absolutely able to help you with if you've got further questions on how to harness the positive side of social media. And we've got some of his contact details up for you. But that does bring us to the end of the time allocated today. Peter Doughman, thank you very much for your time and your expertise.
Thanks so much. Good to be with you.
So many different layers to navigate through there. And also, before you go, please remember today's webinar is intended as general guides only. And we do encourage you to contact Matthews Folbig Lawyers directly for specific legal advice tailored to you or your business. And before you go, please complete the quick three-question survey to which you'll be automatically redirected. We'd love to hear from you, so do give us your thoughts. Don't be afraid and get in there and get involved. Today's program will be made available for on-demand viewing, and we'll be in touch with you with all of those details in the coming days. So thank you very much once again for your company on today's live webinar, and until next time, from us here in the studio, it's goodbye for now.